So you're going through a separation, there's tension, there's emotion, and possibly, no, almost definitely there's passive-aggressive text messages that makes everything more complicated and frustrating. There are kids involved, and now when you come to the question of who gets the kids, it can be one of the most difficult parts of any breakup. But it doesn't have to be. So let's break down 9 things you absolutely need to know about child custody. One of the biggest myths we hear all the time is that court always favors the mother. Gender doesn't give you a free pass in the family court. So if you're assuming you'll get full-time care because you're the mum or the dad, slow down. The law sees parents as equals. It's all about what supports the child's well-being and what's in the best interests of the child. The amount of conversations I've had with parents where they've told me, this isn't fair, why is it like this, why is it like this for me? The law doesn't consider as to what's fair for each parent. The law is more concerned as to what's in the best interest of the child, and sometimes that might seem a little bit unfair for one parent. But the good news is that means that both parents start on an equal footing. The court will look at a whole bunch of things like who the child had a stronger emotional bond with, who has the primary carer traditionally been, who's been more available for school drop-offs, activities, extracurriculars, whether there are any safety concerns for each parent, and they're going to make a holistic decision as to who the primary carer of the child will be and what the spend time arrangements will be for the children. Now let's talk about one of the most confusing terms in family law, parental responsibility. Having shared parental responsibility means you both have a say in the big decisions in your child's life. Things like education, medical treatment, religion, cultural connections, all of the big stuff that makes parenting what it is. Having equal and shared parental responsibility doesn't mean that the child is going to spend exactly half the time with each parent. In fact, a 50-50 time arrangement only works in certain situations, and the amount of times I've had to explain that to different people and distinguish the difference between shared parental responsibility. 50-50 time arrangements do work sometimes, but not all the time. Think about the things that need to fall into place in order for a 50-50 arrangement to work. The parents need to live close to each other. They need to be able to communicate reasonably well, and the child needs to be able with switching between homes. And let's be honest, some parents can barely communicate about school shoes without it turning into an argument, let alone a whole 50-50 arrangement. So yes, you can share decision-making power without having equal time with the child. Point 4, you usually have to try mediation before going to court. Unless there's family violence or serious urgency like the other parent disappearing with the children, you can't just apply to the court straight away. You need to go through family dispute resolution first, and that's a good thing. It's a structured mediation process where a trained professional helps you and your ex work out parenting arrangements without having to go to court and having to go to lawyers sometimes. At the end of the mediation, if you can't reach an agreement, you'll get a special certificate called a Section 60I, and that allows you then to apply to court if you really want to. Now I know sitting in a room with your ex or on a Zoom call with your ex, it doesn't sound like fun, but trust me, it's a lot cheaper and faster than going through the courts, and if it works, you get to move on with your life. And if it doesn't, well, that's when the judge gets involved. 5, kids don't get to choose, but their opinion does matter. People always say to me, my daughter, she wants to spend more time with me, she wants to live with me at my house. Isn't that enough? The short answer is no, not quite. Children don't get to make the final decision, but the court will consider their views, especially as they get older and more emotionally mature. The older the child, the more their wishes carry weight, but it's still one factor amongst many. Just think of this scenario. If a 15-year-old child is saying, I want to live with dad, it's very different to a 6-year-old saying, Mum lets me stay up late and I can eat as much ice cream as I want with her. But it's the court's job to make decisions that protect the child's overall well-being and not just honour who the children may be in favour of this week or next week. Parenting plans. I get this question asked a lot. Parenting plans are good, but they're not enforceable. So if you and your ex are on decent terms, you might be able to create a parenting plan without going to court. And that's great. It shows maturity, it shows cooperation, and your kids will be happy with an arrangement that you're both able to agree to. But a parenting plan is not legally enforceable. It's just an agreement. It's like a written handshake deal. Let me give you a quick example. We had a client at our office, let's call her Anna for anonymous sakes, and she had a parenting plan in place with her ex. Things were going well until he got into a new relationship, and suddenly the pickup times were all off, holiday schedules were completely ignored, and the agreement wasn't being honored. We then got involved and helped her turn that agreement into consent orders. So it was the same parenting terms, but it was now court approved and legally binding. So that means you just don't have to rely on somebody's good behavior, because that can be temperamental, and having consent orders gives you that legal backup and the ability to enforce those orders in the event something goes wrong. If there is a risk to the child, shared care or unsupervised time might not be appropriate. The court might order supervised visits, reduce contact, or put other safety measures in place. The goal is simple: protect children and put that as an absolute priority. their safety and well-being is placed at the highest level and there are no compromises. Now, here's a little tip we like to give our clients. You can get interim orders to keep things stable during a period of time when you're waiting for final orders in court. Let's say you've applied to court and now you're waiting for a final hearing, and that could be 1 or 2 years away. What happens in the meantime? You can ask the court for interim orders, which are temporary orders that can stabilize things. It might be that you want to increase time with the child or you want to decrease time with the child, and all of these things can happen before a final decision is made. Now, just be clear, it's not a final outcome, but it gives you structure during what can be a really unpredictable and unprecedented time. And speaking of going to court is a plan B option. A lot of people come into the office and they think, this is my plan A, I need to get it done through the court system. Court is expensive, it's slow, it can be extremely emotional. So if you and your ex have any possibility of reaching agreement, you can make it legally binding by filing consent orders with the court without ever stepping foot inside the courtroom. You'll save thousands of dollars, months of stress, and you will definitely have more control over the final outcome than leaving it up to the judge. Once you have orders can change, but only if the situation does. And that happens throughout life. Sometimes there's a situation that arises that the court will say, there's been a substantial change in circumstances, and now we might have to revisit these orders. Kids might get older, parents might move, and sometimes what worked 2 years ago just doesn't make sense anymore. And so the court does allow for modifications of parenting orders, but there needs to be a significant change in circumstances. We're talking things like a parent relocation, or a new safety issue has arisen, or maybe there's been a huge developmental change in the child. You can't apply to change orders just because you don't like them anymore. The court wants some kind of stability for the children, so it's not a constant tug of war in court every time you're upset about something. So there you have it, 9 things you need to know about parenting arrangements in Australia. It's emotional, yes, but it doesn't have to be a war. If you focus on what's best for your child and not what gets back at your ex, you're already doing better than half the people in the system. So if this video helped you at all, hit that like button, subscribe for more legal tips, share this with somebody that might need to hear this advice, and if you have any concerns, and if you're feeling stuck or need help turning your chaos into an actual plan, reach out. We help people every day figure this stuff out without the drama. You've got this.